In recent months, a contentious debate has erupted over the role of the judiciary in shaping policy and enforcing legal boundaries. A growing number of officials within the administration have raised concerns about what they call judicial activism, a phenomenon in which judges, rather than strictly interpreting the law, are perceived to be making decisions that serve a political agenda. This accusation has been particularly focused on those within the judicial system who have issued nationwide injunctions blocking key executive actions, effectively halting policy implementation and creating significant legal and political friction. This conflict has been fueled by a series of high-profile cases in which federal judges have ruled against major policy initiatives. Critics argue that these decisions reflect an overreach of judicial power, where personal ideology influences rulings rather than strict adherence to the Constitution. The administration's frustration has been palpable, with some officials openly criticizing judges who have issued these rulings, claiming they are undermining the will of the electorate. This viewpoint holds that the role of the judiciary is not to create policy, but to ensure that existing laws align with constitutional principles. The controversy intensified when legal challenges to executive decisions began to pile up, with judges in certain jurisdictions repeatedly striking down policies that had been championed by the administration. These rulings prompted heated discussions about the balance of power among the three branches of government. Some within the administration have argued that these judicial blocks amount to an attempt to override the authority of the executive branch, which was elected to carry out its agenda. Supporters of this perspective emphasize that nationwide, injunctions have become a tool of political obstruction, allowing a single judge to impose a ruling that affects the entire country. They point to historical precedents, noting that such widespread use of injunctions is a relatively recent development. In their view, these legal maneuvers prevent the government from functioning effectively, creating an environment where policies can be stalled indefinitely through the courts, rather than debated and decided through the democratic process. The other side of the debate, defenders of the judiciary insist that these rulings are not acts of judicial activism, but necessary checks on executive overreach. They argue that the courts play a vital role in safeguarding constitutional rights and ensuring that laws do not violate fundamental principles. From this perspective, judicial intervention is not an abuse of power, but a safeguard against the possibility of unchecked authority. As this legal battle continues, the debate has sparked larger questions about the judiciary's role in shaping national policy. Some have suggested that reforms may be needed to address concerns over the growing influence of federal judges in political matters. Others, however, warn that any attempt to curb judicial authority could set a dangerous precedent, weakening the very institutions designed to provide balance in governance. With tensions escalating, the nation watches closely as legal experts, policymakers, and the public grapple with the implications of these judicial decisions. The ongoing conflict underscores the fragile equilibrium between the branches of government and the enduring debate over how justice should be administered in a democracy. The growing tension between the executive branch and the judiciary has led to serious concerns about the stability of the nation's constitutional framework. At the heart of this dispute is the assertion that a constitutional crisis is unfolding due to judicial actions that, according to critics, obstruct the government's ability to carry out its policies. The issue has been brought into sharp focus by a series of court rulings that have blocked major executive initiatives, leading to accusations that certain judges are wielding their power in a way that disrupts the balance of governance. This conflict is rooted in the belief that judicial interference has reached a point where it undermines the authority of the executive branch. Supporters of this viewpoint argue that the judiciary is not merely interpreting laws, but actively preventing the implementation of policies that were approved through democratic processes. They see this as a fundamental threat to the separation of powers, in which each branch of government has distinct and well-defined responsibilities. The concern is that when courts step in to halt executive actions, they are essentially assuming a role that was never intended for them, creating an imbalance that could have long-term consequences. Legal battles over key policy decisions have intensified these concerns. Judges in various jurisdictions have issued nationwide injunctions that stop executive orders from taking effect, often citing constitutional violations. While such injunctions have been used in the past, their increasing frequency has led to frustration among those who argue that they are being used as a political tool rather than a legal safeguard. This has prompted calls for reform, with some advocating for limitations on the ability of lower courts to impose nationwide rulings that affect government policy. Critics of these judicial actions argue that such interventions amount to an unelected group of officials dictating national policy, despite not being directly accountable to the electorate. They contend that, while the judiciary has a duty to uphold the Constitution, it should not interfere with the execution of policies unless there is a clear and undeniable violation of fundamental rights. When judges consistently block government initiatives, it raises questions about whether they are acting impartially or engaging in political resistance under the guise of legal interpretation. On the other side of the debate, defenders of the judiciary argue that the courts are fulfilling their essential role as a check on executive power. They believe that if certain policies are being halted, it is because they raise significant constitutional concerns that must be addressed. In their view, the courts provide an essential safeguard against potential overreach, ensuring that laws and policies adhere to the nation's founding principles. This divide has led to an increasingly polarized political climate, with legal, scholars, policymakers, and the public weighing in on the broader implications of these judicial decisions. Some worry that if tensions continue to rise, the conflict between branches of government could escalate to a point where the effectiveness of the legal system itself is called into question. Others argue that the situation is a reflection of the growing pains of democracy, where institutional struggles are a natural part of governance. Public criticism of the judiciary has reached unprecedented levels as certain legal decisions have sparked outrage among government officials and their supporters. This growing animosity stems from a belief that some judges are actively working against the policies of the administration, issuing rulings that stall or completely block key initiatives. As a result, an intense debate has emerged over the role of the courts in shaping policy and the extent to which judicial power should be exercised in matters of governance. Prominent figures within the administration have taken to public platforms to express their frustration, openly challenging the legitimacy of court rulings that conflict with their agenda. In speeches, press conferences, and social media statements, officials have accused certain judges of deliberately obstructing progress, arguing that their decisions are motivated by political bias rather than legal reasoning. The argument is that these judges are not merely interpreting the law, but are instead engaging in activism that undermines the will of the electorate. As tensions have escalated, calls for drastic action against members of the judiciary have grown louder. Some supporters of the administration have suggested that judges who repeatedly issue rulings against executive actions should face consequences, including impeachment or other forms of disciplinary action. This sentiment has been amplified through news outlets and social media platforms, where narratives portraying the judiciary as an obstacle to national progress have gained traction. The idea that judges should be held accountable for their decisions has ignited fierce debates, with some arguing that such measures are necessary to prevent an unelected judiciary from overstepping its bounds. At the center of this controversy is the broader question of judicial independence. While critics of the judiciary insist that certain judges are abusing their authority, legal scholars and members of the legal community have pushed back, warning that direct attacks on the judiciary could undermine the fundamental principles of democracy. They argue that an independent judiciary is essential to maintaining the rule of law, ensuring that the government operates within constitutional boundaries. Any effort to intimidate or remove judges based on their rulings, they caution, could set a dangerous precedent that erodes the checks and balances designed to prevent any one branch of government from becoming too powerful. Despite these warnings, public distrust of the judiciary continues to grow among certain segments of the population. Some see the courts as an institution that serves elite interests rather than the needs of everyday citizens, fueling further resentment. The belief that judges are making politically motivated decisions has led to increased skepticism about the legitimacy of the judicial system as a whole. This skepticism is reinforced by media coverage that highlights controversial rulings, portraying them as obstacles to the administration's ability to govern effectively. As this debate rages on, the judiciary finds itself in an increasingly precarious position. Efforts to defend judicial independence are met with resistance from those who feel that the courts have become an obstacle rather than a safeguard. Meanwhile, supporters of the judiciary argue that efforts to discredit the courts pose a greater threat to democracy than any individual ruling ever could. The escalating rhetoric against the judiciary has sparked deep concerns among legal scholars, judges, and constitutional experts who warn that such attacks threaten the foundational principles of judicial independence and the rule of law. The legal community has increasingly voiced apprehension that public criticisms, especially those targeting individual judges, could erode trust in the judicial system and weaken the essential checks and balances that sustain democratic governance. 1. Of the central concerns is that repeated efforts to delegitimize the courts may undermine judicial review, the process by which courts assess the constitutionality of laws and executive actions. This function serves as a crucial safeguard to prevent any branch of government from exceeding its authority. Legal experts argue that when members of the judiciary face public condemnation for their rulings, it creates an environment where judges may feel pressured to rule in ways that align with political interests, rather than adhering strictly to the law. This could compromise the impartiality that the judiciary is designed to uphold, ultimately weakening the integrity of the legal system. Many within the legal community point to historical examples where attempts to weaken the judiciary led to a decline in democratic institutions. In nations where judicial independence has been eroded, courts have often become mere extensions of executive power, rubber-stamping policies rather than serving as a check on potential abuses. Legal scholars fear that if judges are intimidated into ruling a certain way due to public pressure or the threat of political retaliation, the courts will lose their ability to serve as a neutral arbiter in disputes involving government power. Beyond. The immediate legal implications concerns have also emerged about the long-term impact on public confidence in the judicial system. When a segment of the population comes to believe that the courts are illegitimate or biased, faith in the justice system diminishes. This loss of trust can lead to a dangerous breakdown in societal cohesion, as individuals and institutions may begin to disregard judicial rulings they perceive as politically motivated. If widespread distrust in the judiciary takes hold, enforcing the rule of law becomes increasingly difficult, and the stability of the entire legal framework is put at risk. In response to these challenges, many judges and legal organizations have spoken out in defense of judicial independence. They argue that while criticism of court rulings is a normal part of democratic discourse, efforts to delegitimize judges themselves go beyond fair debate and enter the realm of undermining core democratic principles. Organizations dedicated to upholding the rule of law have urged the public and government officials to recognize the importance of an independent judiciary and to resist calls for actions that could weaken it. Legal scholars also emphasize that the judiciary has historically played a pivotal role in safeguarding individual rights and maintaining constitutional order, even in the face of political pressure. The ability of courts to function without fear of retribution ensures that all branches of government remain accountable. Preserving this independence, they argue, is not just a matter of protecting judges. It is about protecting the fundamental democratic structures that uphold justice for all. The ongoing conflict between the judiciary and the executive branch highlights a fundamental struggle over the balance of power in government. While disagreements over judicial rulings are not new, the current level of tension has raised pressing questions about the role of the courts, the limits of executive authority, and the long-term health of democratic institutions. At the heart of this debate is the concept of checks and balances, a principle designed to ensure that no single branch of government wields unchecked power. As this struggle unfolds, the nation is forced to confront difficult questions about the future of its legal and political systems. Supporters of the judiciary argue that judicial independence is essential for maintaining the rule of law. Without courts that can freely interpret the Constitution and review government actions, there is a risk that executive power could grow unchecked, leading to potential abuses. Judicial review ensures that laws and policies adhere to constitutional principles, providing a safeguard against overreach. Critics of recent attacks on the judiciary worry that if judges are pressured to align with political interests, the courts will lose their ability to function as impartial arbiters of justice. The erosion of judicial independence, they warn, could have far-reaching consequences, weakening the very foundations of democracy. On the other side, those who support stronger limitations on judicial authority argue that courts should not have the power to repeatedly block executive decisions, especially when those policies have been approved through democratic processes. They believe that some judges have overstepped their intended role, effectively legislating from the bench rather than interpreting the law. In their view, excessive judicial intervention disrupts the balance of power and prevents elected leaders from carrying out the will of the people. The growing use of nationwide injunctions has only intensified these concerns, with critics calling for reforms to limit the ability of individual judges to halt government policies on a broad scale. As these debates continue, the legal community remains deeply concerned about the long-term implications. A judiciary that is seen as either too weak or too powerful risks losing public trust. If courts are perceived as political tools, their legitimacy erodes, and their ability to function as neutral interpreters of the law diminishes. Likewise, if the executive branch is perceived as undermining judicial authority, it raises fears that democratic institutions are being weakened. The challenge lies in finding a balance that preserves the independence of the judiciary, while ensuring that courts do not become obstacles to effective governance. Ultimately, the resolution of this conflict will shape the trajectory of governance for years to come. Whether through legal reforms, shifts in public perception, or structural changes in how the judiciary operates, the outcome will determine the extent to which the courts remain a strong and independent check on power. While disagreements over judicial authority are inevitable in any democracy, how these disputes are handled will test the resilience of democratic institutions. The choices made now will define the future of the legal system and the balance of power between branches of government, influencing the nation's ability to uphold justice and maintain the rule of law.